Criminal cases, Government Unit 4A. Criminal cases. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. This according to the Sixth Amendment of the Constitution. I'm going to clarify a little bit more what that means. When we see a right to a speedy and public trial, that doesn't necessarily mean that everything in the trial is going to be made available to the public, and that doesn't necessarily mean, speedy doesn't mean right away. Speedy could mean basically without unnecessary delay. Oftentimes there's a backlog in the court system, so things don't happen as fast as we might like. But it's the point of that is that they don't want people to be locked up while waiting for a trial that's delayed simply for the basis of keeping them locked up. And once again, the idea of an impartial jury is that the jury should be unbiased, and it should be a jury that is composed of people where the crime took place. Now, there are some exceptions where a trial can be moved, and we'll talk about that a little bit later, why there might be a change of venue. But generally speaking, it should generally be where it took place. For example, usually in the same county. And once again, they should be informed of the nature and the cause of the accusation. Whatever they're charged with has to be presented to them. They have to be confronted with the witnesses against them. In other words, they have the opportunity to see who is making these accusations against them as this goes through a court of law. And this idea of having a compulsory process, what that means basically is that there is a way that they can force people to testify. And that's really through the process of subpoenaing witnesses. Subpoena is basically a legal order to appear, and they can use that frequently times. So, that's what compulsory means, is basically mandatory. They can force people to testify. So, if I know somebody is a potential witness for me and I'm accused of a crime, I could force them. I could have them subpoenaed so that they're forced to testify, even if they don't feel like testifying. And then, once again, to have assistance of counsel, what that means is basically they have the right to an attorney. And we now know that not only do they have the right to an attorney, but if they can't afford one will be appointed for them. That's called a public defender. A primary function of the criminal justice system is to punish people who have committed crimes. The process established by our government involves numerous steps that often lead to backlogs and delays. However, these are a necessary evil because through the U.S. Constitution, all Americans, regardless of the crime that they're accused of committing, are guaranteed basic fundamental rights. Balancing the rights of the accused with the responsibility of protecting society is a daunting task for those who work in the justice system. In a criminal case, the accused is charged with committing an offense against the public in general, although an individual may have been wronged, and in such cases, these individuals are free to file a civil suit against the defendant. Now, it's important to note here what we're talking about. We say a criminal trial. Crimes aren't committed against individuals per se. The crime is against society. And that doesn't mean there can't be a victim of that crime, but it's a crime against society. In other words, they broke the law by doing something that is criminal. Now, victims who are damaged by that criminal act can file suit for those damages. So let's take the case of a murder. If somebody has murdered somebody, yes, there is a victim. The individual that was murdered is a victim, but it's still considered to be a crime against society. And so they're charged with committing murder. That's the criminal trial, and that is, once again, a crime against society. Now, the victim's family could then file a wrongful death lawsuit against the accused. And important point here is that in a wrongful death lawsuit like that, which is a civil suit, it is not necessary that they get a conviction in the criminal case. One example of this was the O.J. Simpson trial, where O.J. Simpson was accused of murdering his ex-wife, Nicole Brown Simpson, and another man named Ron Goldman, who had the misfortune of being basically in the wrong place at the wrong time. In the criminal trial, O.J. Simpson was acquitted. He was found not guilty. Now, it's important, also an important distinction to note that a not guilty verdict doesn't mean that the person is innocent. Our courts do not find people innocent, and that's because there's no burden to prove you're innocent. The burden falls on the state, or who's bringing the charges. They have to be proven to be guilty. There is a presumption of innocence, and a not guilty verdict simply means that the burden of proof was not established. They didn't prove beyond a reasonable doubt that the person was guilty. Not meaning, of course, that they're innocent. Most people believe that O.J. Simpson was guilty, and the general public, that's kind of seems like it's been a consensus opinion ever since the trial. But the criminal case found him not guilty. And once again, when you're found not guilty, you cannot be tried for the same crime twice. So he was acquitted. That's all that could be done. So the families turned around, and then they filed a civil lawsuit for wrongful death. Now, there's a different standard of proof in a civil case. They just have to prove a preponderance of evidence, which basically means they have to prove that there's more evidence the person is responsible than they're not responsible. So it's a lower burden of proof to hit than to prove somebody guilty beyond a reasonable doubt. So in that case, O.J. Simpson was found to be responsible for their deaths, and even though he was acquitted of the murders. However, in most civil cases, the punishment is financial. And O.J. Simpson did a good job of hiding his assets so that he didn't have to surrender a lot of things. Now, kind of an ironic twist, many years later, O.J. Simpson, having given away a bunch of his possessions to get them out of his name, lost control of some of his sports memorabilia and decided he was going to steal it back at gunpoint. And for that, he ended up being charged with armed robbery and was convicted. And so then he later went to prison for armed robbery. Now, the process. After an investigation, the government, working on behalf of the people in a state or the people of the United States, arrest a suspect, in this case for kidnapping, we'll call him Larry, and they charge him with a crime. Police can't use this power indiscriminately since they must have probable cause, which is a good reason to believe that Larry has been involved in a crime. According to law, when a person is arrested, the police must read him his Miranda rights. These rights came out of a Supreme Court case, Miranda versus Arizona, in 1966, where the court found that it is the duty of arresting officers to inform someone of their rights. So ever since then, we've had the Miranda rights, and people have become very used to them. Most people kind of know them. which is, of course, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be appointed to you, etc., etc., etc. So they have to read them the rights, and then, well, here you can see, actually right in the text, Larry would be told, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney present with you during questioning. If you cannot afford one, one will be appointed to you by the court. Do you understand? After the arrest, Larry is booked, fingerprinted, photographed, arrest records are filed, and his personal information is entered into a database for future reference. But before he's locked in a cell, he has the right to make one phone call. And he will probably call a lawyer or someone who can find a lawyer for him. Larry's case is then handed over to a prosecuting attorney who represents the government. If the prosecuting attorney believes the case against Larry is weak, he may drop the charges and Larry will be released. However, if the prosecuting attorney thinks that there is enough evidence to put Larry on trial, a preliminary hearing is held. And so I said, this is one of those situations where usually it's the district attorney, in most cases, they're going to make that decision, that determination. And so if a preliminary hearing is held, Larry has the right, as do all persons accused, because of a writ of habeas corpus, which is a court order that guarantees him a right to appear before a judge in a court of law. And so at this point, the preliminary hearing is held. He appears before the judge. At the preliminary hearing, which must occur soon after Larry's arrest, the prosecuting attorney must show the court that a crime has been committed and that there's enough evidence against Larry to charge him with the crime. If the judge agrees, he may set bail or he may release Larry on his own recognizance. In this case, if the judge feels that he's a flight risk, he may completely deny bail. And a flight risk is somebody who they think is likely to flee. In most severe cases, bail may be set very, very high. For more minor cases, bail is usually a much lower amount. And then, like I said, in some cases, especially if the crime isn't that severe and they don't think Larry's much of a flight risk, releasing him on his own recognizance simply means that he's allowed to basically go free until the trial. And if the judge disagrees, he'll dismiss the case and Larry will be released. So it's really up to the judge's discretion whether he thinks there's enough evidence. Assuming that the judge rules in the prosecution's favor, according to law, Larry must be given the opportunity to have a lawyer, even if he can't afford one. Public defenders are lawyers who work for the government and who represent defendants who can't afford legal counsel. Now, there's definitely an argument that says that you kind of get what you pay for. I mean, if you have the money to hire the best attorneys that money can buy, you are less likely to be convicted. If you're stuck with a public defender, that doesn't necessarily mean that the public defender isn't a good attorney. But then again, the public defender doesn't have all the resources and may not be as good as somebody in private practice. But once again, even if you go for somebody in private practice, the more you can afford to spend generally, you can get a better attorney. Now, of course, that doesn't mean that just because an attorney is expensive that they're good either. But certainly, better attorneys can usually charge a lot more. So we'd like to think that our court system is fair and equal, but in that sense, it isn't very equitable because, yeah, if you can afford the best attorneys, you do have an advantage. The grand jury. Larry's case is then turned over to a grand jury. The grand jury is composed of 16 to 23 citizens who review cases and decide whether or not there's enough evidence to formally charge Larry with a crime. The grand jury does not decide guilt or innocence. Rather, its job is to determine whether or not there is probable cause that Larry committed a crime. If it doesn't find probable cause, the case is dismissed. If the evidence does indicate probable cause on Larry's part, the grand jury will return an indictment, which is a formal charge against the accused. So you can see this is kind of a multi-step process. The judge at the preliminary hearing could have ruled that there wasn't enough evidence and Larry could have been released. Or things could move to the grand jury, but the grand jury may fail to indict, at which point Larry could be released. But if the grand jury does find that there's enough evidence and they issue that indictment, then they basically made a formal charge and it moves forward to the next step, which is arraignment. After the indictment, Larry will consult with his lawyer before appearing in court again for his arraignment. At this court hearing, Larry enters a plea of guilty, not guilty, or no contest. The defendant, under no contest, the defendant doesn't admit guilt, but acknowledges that a jury would probably convict him based on the evidence. So it's not quite the same thing as a guilty plea. A guilty plea, you're basically saying, yeah, I'm guilty, I did it. Not guilty, you're going to fight it. No contest, you're not admitting guilt, but you're not going to fight it because you know it probably wouldn't be successful. If Larry enters a plea of no contest or guilty, the judge will sentence him and the case is over. Larry may decide to plead no contest or guilty if the evidence against him is strong, because through a plea bargain, he will receive a lighter sentence. Most cases are settled in this way. If Larry enters a plea of not guilty, then the judge will set a trial date. Pre-trial motions. Before the trial begins, the lawyers for both the prosecution and the defense may file motions to suppress certain evidence or statements, or perhaps to ask the judge for a change of venue, which means moving the trial to a different location, usually because of extensive pre-trial publicity. One case where this happened, that was a local case, was the Scott Peterson murder trial. Scott Peterson was charged with murdering his pregnant wife, Lacey, and their unborn child. And, leading up to that case, there had been a great deal of media attention nationwide. Lacey Peterson went missing on Christmas Eve. And back in, I think it was 2002, I believe. And so, it's now been several years, but she went missing, and for really probably, at least a couple of months, 2 or 3 months, they were searching for her, searching for answers, trying to figure out what happened to her, and no one knew whether she was alive or whether she was dead. Eventually, her remains, along with the remains of their unborn child, Connor, washed ashore, and shortly after that, Scott Peterson was arrested and charged with the murder. And the case, like I said, was attracted so much public attention. Within a few days after her disappearance, it was all over the national news media. And so there had been so much media attention, it was hard to find people that hadn't followed the case and had an opinion about it, even on a national basis, but especially here in the local area. And so there was a change of venue. I can't remember exactly what county they moved it to. It was somewhere kind of more towards the Bay Area, but they did get it out of Stanislaus County because of the intense media coverage that had existed. In a situation like that, where a case has been so high profile, it is hard to find a jury that hasn't been tainted, or a jury pool, I should say, that hasn't been tainted at all. But it is what it is, and so that's why typically you have a change of venue. Also, as a part of the pre-trial motions, They will issue subpoenas or court orders requiring a person to appear in court that are sent to witnesses. And once again, I mentioned that compulsory process. The defendant can compel people to testify, but the prosecution also can subpoena witnesses as well at this point in time. Then we move forward to the main trial, which is known as the Petit Jury. Before the trial begins, Larry will be asked if he wants a bench trial. Approximately 10% of all criminal cases are bench trials, which is simply a trial by a judge who decides the verdict. However, Larry will probably opt for a trial by a jury of his peers, formally called a Petit Jury. Once the trial begins, Larry's fate will lie with this group of men and women who hear the evidence and decide whether or not Larry is guilty or not guilty. Jurors are selected after extensive questioning by the judge and the lawyers. So, selecting the jury, known as the voir dire, and I probably butchered the pronunciation of that, it's Latin. The first step in a criminal case is the selection of an impartial jury. Serving on a jury is both a privilege and an obligation. Most people truly don't want to get jury duty, but from a standpoint of making our system work, it is important that we can compel people to serve on juries. Our system would not work if we didn't have jurors. In a democracy, it is essential for the citizens to participate in the criminal justice system if the government of the people is to survive. So, while I never like getting a jury summons and always hope that I end up not on the jury, at the end of the day, it's important that we participate. Not all citizens are eligible for jury duty. Therefore, being selected to decide the fate of a peer is a privilege that is not granted to all. Although each state establishes its own guidelines regarding jurors, in most states, potential jurors must be between the ages of 21 and 70. And they must be literate, meaning they can read. And they can't have a felony conviction. All jurors must be U.S. citizens either by birth or through naturalization. States derive their juror list in multiple ways, but most states use tax lists, the list of registered voters, or the list from the Department of Motor Vehicles. Drawn randomly from these lists, citizens are notified to come to court for jury duty. Collectively, they are called the jury panel. On the day of a trial, there may be as many as 150 jurors. Of this number, generally 12 will be selected as jurors along with 2 alternates. There may be as few as 6 jurors on a case, and this really varies a little bit depending upon the particular laws of the state. But generally it's going to be about 12 with 2 alternates. The alternates don't participate in deliberations, but they sit through all the testimony in the trial. The whole purpose of being an alternate is that should, for some reason, one of the jurors who's actually, one of the main 12 jurors not able to fulfill their duty, then they would be replaced by the alternate. Jurors from the panel are selected randomly, usually by lot, until the jury box is filled. At the opening of court, the judge calls for excuses, and the jurors who believe that they should be excused are asked to give their reasons. The judge listens to each excuse and rules on each case immediately. Excuses such as having to care for a seriously ill family member will usually lead to dismissal. Excuses such as previous engagement, such as tickets to a sporting event, for example, will not be valid. The judge looks at the circumstances of each individual juror before making a final decision. And sometimes a juror may decide to leave the judge may decide to leave a potential juror on temporarily and kind of see what develops. But as they do this and they make potentially excuse some jurors, how strict the judge will be depends on a wide variety of factors. Partially depends on the judge. Some judges are probably just more lenient than others, and also it probably depends on how close they are to filling the jury. If the judge is very confident that he's got uh, a good selection of potential jurors and he's not going to have a problem filling any remaining spots, he might be more willing to accept an excuse that he otherwise normally wouldn't accept. There isn't a precise line where we can say, well, this excuse is absolutely going to be, we get a juror excused, and this absolutely wouldn't. It's a little hit and miss. After the excuses have been heard and the jurors dismissed, if necessary, additional jurors are called so that the number of jurors in the jury box remains consistent. The jurors are then questioned by the judge and then by the lawyers. In a criminal case, the defense questions the jurors first and is followed by the prosecution. This preliminary examination is called the voir dire, and its purpose is to obtain a fair and impartial jury. Jurors may be asked about their personal lives, about their relationship to any of the parties involved in the case, about any aversion to the type of case being tried. For example, if let's say somebody has an objection, a moral objection to the death penalty, and it's a murder case where the death penalty is a possible verdict. That person might be excluded for the simple reason that morally they might have a hard time convicting. So they'll look at things like that. They'll look at the previous knowledge of the case that they might have, and once again, that could tie into how closely they followed the case in the media. Regardless of the type of question asked, all jurors must respond truthfully. The lawyer's questions are not intended to offend jurors, although sometimes they do. And since they don't want to alienate a juror who will be deciding the outcome of the case. In other words, if you're an attorney and you're asking a question of a potential juror, you do want to be able to excuse a potential juror that you think may be bad for your side. But in doing so, you don't want to alienate them in case they do end up on the jury, because then you may have already turned them against your side in the case. After questioning, jurors may be excused in one of two ways: a challenge for cause or a peremptory challenge. A lawyer may ask for a challenge for cause, which is a request to the judge that a juror be removed for a specific reason. The reason stated must show that the juror can't be impartial in the case. Some examples are a prior relationship between the juror and one of the parties in the case, prior knowledge of the case in which the juror has already formed a concrete opinion, or a prejudice on the part of the juror. So this is something that, like I said, the attorneys are trying to determine. They're going to ask questions, and they're looking to see, one, if they do have a clear cause where they can, make a challenge for cause. But if they're making a challenge for cause, they have to state why. And they have to convince the judge that this person is not an impartial, or would not make an impartial juror. So keep in mind that all people have prejudices because of our backgrounds, lifestyles, experiences, etc. Therefore, a lawyer must prove the juror's prejudices will inhibit the juror from being impartial in the case before him. After the lawyer makes his argument, the judge must decide whether or not he agrees. If he agrees, the juror is excused. If he disagrees, the juror remains unless the lawyer chooses to use one of his peremptory challenges. And there is no limit on the number of challenges for cause that a lawyer may use. But keep in mind that every challenge for cause, the lawyer has to prove that that person, to the judge's satisfaction, that person would not be a good or an impartial juror. If a lawyer has a bad feeling about a juror, or he believes that the person is biased, maybe he just has a gut feeling about it, but he can't offer substantial proof for dismissal, the juror may be excused through the use of a peremptory challenge. According to state laws, each side is given a limited number of peremptory challenges, but they can be used at any time to excuse a juror without stating any cause whatsoever. Usually they're going to go through and question, and if they find a good case that they think they can really make a challenge for cause, they'll make a challenge for cause. If they're unable to do that, then they'll go to the peremptory challenge. We have definitely used peremptory challenge, or seen peremptory challenges used before. The last time I got called for jury duty, I actually was in one of the alternate chairs. And kind of the way that things would work is that they were at that point where, in the event that they'd gone through basically all the challenges for cause, so the jury was basically set except for peremptory challenges. So each side had peremptory challenges. And they went to the prosecution first, asked the prosecution if they wanted to use any of their peremptory challenges. The prosecution rather, did not use any of their peremptory challenges. They had two. So then they went to the defense, and the defense chose to dismiss me and then chose the person sitting next to me as peremptory challenges. But we were basically at that point, based on where I was sitting, I would have been at least an alternate had I specifically not been excused. So that's how close it was. But ultimately, the defense didn't have a good feeling about me for whatever reason. But they didn't have to state it and make that case. They just, if they felt uncomfortable, and if for any reason any of the potential jurors have the least little bit of doubt in that juror, they might as well use their peremptory challenges because they want to get the most favorable jury they possibly can. The judge cannot overturn a peremptory challenge, nor can the opposing side object to it. When using a peremptory challenge, the lawyer simply states the prosecution exercises a peremptory challenge against Mr. Williams, and Mr. Williams must step down. As jurors are dismissed, new jurors are called to take their place. When the selection of the jury is completed, the judge orders the clerk to swear in the jury. And the oath states, "You and each of you do solemnly swear or affirm that you will, well and truly, try the issues joined in the cause now here pending, and unless discharged by the court, a true verdict render, and that you will do so solely on the evidence introduced and in accordance with the instructions of the court, so help you God." After the jurors swear in the affirmative, the trial continues with the opening statements. After the jurors are selected, the trial begins with the lawyer's opening statements. The prosecution gives its statement first. The prosecuting attorney outlines the case and tells the jury about the evidence that he plans to present to prove his case. The defense lawyer may follow immediately and give his opening statement, or he may wait until the prosecution rests its case. Jurors must remember that these statements are not evidence. Their purpose is to give the framework, the points of conflict, and the issues of the case. Then we move on to testimony. The next phase of the trial takes place when witnesses are called and questioned by both sides. After both sides have rested their cases, each lawyer gives his summation or closing statement. In most states, the defense gives its statement first, and then the prosecution follows. This is the lawyer's last opportunity to address the jury, so they will reiterate the facts that support their sides in a final attempt to convince the jury that they are right. Then, after receiving instructions from the judge, the jury retires for deliberations. In some states, the jury not only determines guilt or innocence, but also decides the sentence. Verdict. A jury must decide unanimously if Larry is guilty beyond a reasonable doubt. If the jurors are not sure, they must find Larry not guilty. If the jury can't decide, it is called a hung jury and a mistrial is declared. However, jurors must make a concerted effort to reach a verdict, and often jurors are repeatedly told by the judge to go back into deliberation until a verdict is reached. The judge doesn't want to declare a mistrial. So if they're unable to reach a verdict, the judge is likely to send them back and continue to send them back until the judge is convinced that there is just no way that they're ever going to reach a verdict. But like I said, the tough thing is that they really need the jury to be unanimous. To get a guilty verdict, everybody has to vote guilty. If it's divided, if everybody says not guilty, it's not guilty. If everybody says guilty, it's guilty. But if it's divided, they have to keep trying until they either reach a verdict and the judge is satisfied, or finally the judge may declare a mistrial. So if it goes that far and it becomes a mistrial, the reason why the judge doesn't want to declare a mistrial, will send them back time and time again, is primarily because of the time and the money that has been spent on the trial. You have to remember, trials are extremely expensive for both the prosecution and defense. In the event of a mistrial, if it's declared, the prosecution has the option of trying the defendant again or dropping the charges. And such a retrial is not considered to be a violation of the constitutional protection against double jeopardy because a verdict hasn't been handed down. Once acquitted, in other words, once found not guilty, they cannot be charged again. However, if they don't determine a verdict, they haven't handed down a verdict, they simply declare a mistrial, the prosecution still has the ability to try that case. But in that situation, there is going to be a tremendous expense for the state to retry that case. And ultimately, they have to ask that question. Is it worth it? Would they have a good shot at getting a conviction in a retrial? And that's what they have to determine. If they don't think there's a good shot, a really good shot, at getting a different verdict the next time around, they think it's likely to end in a hung jury or an acquittal, they're not going to waste the money, they'll drop the charges. After the jury has reached a verdict, it returns to the courtroom and the judge asks if it has arrived at a verdict. And the foreman, speaking on behalf of the group, answers in the affirmative. If the defendant is found not guilty, he is acquitted. And if he's found guilty, he can appeal the decision. After the foreman reads the verdict, the clerk calls on each juror by name and asks them if they agree with the verdict. After the jury has been polled, the jury's function is complete. The lawyers may continue to make motions and the case may be appealed, but the judge will excuse the jurors. Now, like I said, in some cases, the jurors do have a say in sentencing, but not always. But when they've determined the guilt and the verdict is determined, like I said, in the case of an appeal, if it's a murder case, where there's the death penalty, there is indeed a mandatory appeal. It's automatic. Normally, to gain an appeal, they have to show that there has been something done that wasn't right, which usually isn't too hard. They find some mistake, or they claim the judge acted improperly, or that maybe they could claim the defense attorney was incompetent, or there's all kinds of different things that they could claim. But they just need just enough doubt to open the door for a possible appeals trial. Now, after all of that's done, they move to the sentencing phase. If Larry's found guilty, the final step in the court is the sentencing phase. Most states set a maximum and a minimum sentence for each crime, thus leaving room for the judge to decide the exact sentence. The judge will consider many factors when making his decision, such as the nature of the crime, Larry's previous criminal record, his age, and his attitude. If Larry receives his sentence, or after Larry receives his sentence, the trial is over.